Chapter 6, Part 3, Video 3. We finished shopkeeper's privilege. Now we're moving on to the intentional tort of intentional infliction of emotional distress. This is a tort that when I was in law school and we studied, we were told, and this was true, that courts would rarely accept this or apply this doctrine. And the reason for that is it's a little bit more difficult to establish the necessary facts to prove this, and it's too easy kind of to falsify the facts. But now it is much more common to use this type of tort to try and get a remedy. So what it involves is extreme and outrageous conduct that's either intentional or reckless, and it's beyond the possible bounds of decency. It does not require what we call publication to a third person, and in some states it has to have some physical injury as well as the emotional injury. In some states, emotional injury is enough. So the example I like to give of intentional infliction of emotional distress is, suppose we have two women who live across the street from each other and are not getting along at all and are constantly bickering with each other over a lot of different things. Don't mean this to be sexist, so we can have fathers as well, or men as well. Okay, so what happens in this case is that parent A tells their child, who's 6 years old, you can go up the street to the corner and play with Johnny at his house. Okay, so the other parent, after a while, knocks on the door of parent A and says, I just thought you should know that there's been a car accident and little Johnny was hit by a car. Okay, well, the parent gets obviously very upset, runs down to the corner to find out what's going on and if their child's seriously injured or dead or whatever, and finds out that nothing happened. Okay, that's extreme and outrageous conduct. It was intentional, trying to upset this person. It's beyond the bounds of decency, so that can be, in some states, a tort of intentional infliction of emotional distress. Some states also have, and I may have a slide on this, another related tort, which is negligent infliction of emotional distress. In those situations, it's similar, except it wasn't the intent of the person to cause the emotional distress, but their negligence in the way in which they acted caused that. So the First Amendment has some role here. If it consists of free speech, protected speech, then there's not going to be a tort. Okay, so that brings us to another tort, which we said may or may not be in the category of intentional torts, and that's defamation. So defamation involves wrongfully hurting a person's good reputation. The law imposes a duty to refrain from making false statements about others. If you do it orally, it's called slander. If you do it in some sort of media, print or video or audio, then it's libel. Of course, libel is more serious than slander, and the reason for that is that libel can continue on forever because something that's written doesn't disappear unless you destroy it. Whereas slander ends after the words come out of the person's mouth. And so it can have much more damage if it's libel, because somebody can pick it up 20 years later and still read or watch the false report or whatever. It also occurs when the statement is about not a person, but a person's product, business, or property rights. Okay, so the elements of a case of defamation, and these have to be proved, every one of these elements, by the plaintiff in order to win, is that there was a false statement of fact made. So the flip side of that is that truth is an absolute defense. Okay? The statement was understood as being about the plaintiff and tended to harm the plaintiff's reputation. Okay? Now, notice, and we may have a slide on this, it doesn't have to use the plaintiff by name as long as the statement itself would be recognized by most people as applying to a certain person. Okay? So, if you were saying something false about the manager of the New York Yankees, and you didn't use his name, but you said the manager of the New York Yankees, that would be sufficient because everybody would know who you're talking about. Okay? The statement has to be published to at least one person other than the plaintiff. What the word published means here is it has to be heard or seen by this third person. So if I call one of you into my office, and it's just you and I in the office, and I say you're a lying, cheating student, and it's not true, it's not defamation because there's nobody else in the room. There's no publication. On the other hand, if I say it in front of the class, then there's publication, and that can be a wrongful action and establish a case for defamation. Okay, now defamation has a problem as well with the First Amendment. So we're talking about freedom of speech. So how has the Supreme Court dealt with this? Well, generally, you cannot make false statements about people that harm their reputation, and that is not protected by free speech. However, if the person you're making the statement about is a public figure, then the Supreme Court has applied a middle ground test, so to speak. Okay? So, in that situation, where you're talking about the defamation being against a public figure, then you're talking about the plaintiff having to prove more than that the statement was made and that it was false. You have to prove that the defendant made the statement either with the knowledge that it was false or with reckless disregard for its falsity or truthfulness. We call that actual malice. So actual malice can be one of those two things. Okay, a classic example of this is and you probably may have seen the movie Richard, what's his last name? Jewell, Richard Jewell. Richard Jewell was the, I guess he was a security guard during the 1996 Olympics at the downtown Atlanta, and the bomb went off, and he allegedly, I think, found another bomb. I can't remember exactly what it was. But at the beginning, he was a hero. And then he became one of the suspects, or one of the people that the FBI was looking at. The Atlanta Journal-Constitution wrote a story that said that he was the primary suspect in the case, something to that nature, which was actually false. Okay? At any rate, the interesting part about that was if Richard Jewell was an ordinary person, then it would probably be an easy case to win because the statement was false and it affected his reputation. If he was a public figure, however, he would have to show that the newspaper acted with malice. So the court had to decide, was he a public figure or not. Now, originally, public figures were limited to people like politicians. Then it was extended to people like celebrities who are out in the public as well. Now, the Supreme Court has also ruled that a person who's not ordinarily a public figure can become one in a given situation if they thrust themselves out into a public forum or a public discussion. And ultimately, that's what the appellate courts ruled in the Jewell case, was that, yes, because he voluntarily gave interviews to the media, he put himself in the position of being a public figure. Very interesting case, and those areas of law are very interesting. Okay. Now, statements of opinion are protected free speech. That's why you often see things categorized on TV or in newspapers as, well, it's my opinion. And that's the difference between an editorial in a newspaper, which is an opinion, versus an article that is alleging facts. So it's not actionable in those situations. So we talked about publication being a requirement. If the third party heard it by chance, not necessarily listening for it, that's usually enough. Internet statements can be defamatory. In fact, if you talk to judges of small claims courts, they will tell you that in the last 15 years, the number of lawsuits brought in small claims courts have grown exponentially because of people suing each other about statements that were made on Facebook or other social media. Somebody who repeats a defamatory statement can also be liable. I believe a long time ago the courts ruled that many social media are not people who are repeating a defamatory statement, but only providing a platform for somebody, and therefore the liability is less, if at all, for those social media groups. Okay, the damages for libel and slander, it's presumed that there's some damages. So you can prove special damages or compensatory damages by showing, for example, loss of income, if it's a business, etc. And these can include disgrace, dishonor, humiliation, injury to reputation, and emotional distress, most of which are not things that you can put a clear monetary amount of, but would be up to a jury depending upon the nature of what was said. Slander also provides for damages. Now, slander per se, it applies to only certain kinds of slander. And if the statement that's made that's false has to do with alleging that the person has a loathsome communicable disease, like syphilis, or you're alleging business improprieties, that the person is cheating on their taxes, or a serious crime, or serious sexual misconduct, that is slander per se, and you don't have to prove any particular damages. The damages are general damages that flow from the statement itself, and it'll be up to a jury to determine. Okay, defenses. I may be running out of bandwidth, so I'm going to stop there with video 3, and we'll pick up with video 4.